I'm James Piotrowski, and this is Chapter 4, Handling Fair Hearings. There are multiple steps in the fair hearing process. As we discussed previously, there's an informal review process that precedes it, but the whole process actually starts with the appeal letter or notice. That's either the appeal form that came with the budget notice or your own letter or other document that starts the appeal. The step after that is either the informal review or extended informal review that Richie talked about more in the previous chapter. At the end of that process, you and your client will receive an informal review notice. This is a letter explaining either what the department is willing to do to try to resolve the case, or explaining that they believe the correct decision was made initially and that they are not prepared to make any settlement offer at that time. The informal review notice is new as a result of the KW litigation. It should provide a detailed statement of the reasons for the decision that was rendered, why the department thinks that was the correct decision, and why they don't agree with whatever statement you included in your appeal notice. That's going to be an important document as you move forward. Once you've gotten past informal review and the case is not resolved, you'll then get a notice of a pre-hearing conference. It's at that stage, before the notice of pre-hearing conference, that the case is actually assigned to a hearing officer. The hearing officers in the Idaho Medicaid program are deputy attorneys general, working with a separate division of the Attorney General's office, whose main focus is to serve as hearing officers or administrative law judges. The hearing officer will send out a notice of pre-hearing conference that establishes a time and a date for a telephonic conference. This is an informal process. It's essentially a chance to get on the phone with the people representing each side and the hearing officer and to discuss the case. At the pre-hearing conference, you're going to be asked whether there are any particular issues with this case that take it out of the run-of-the-mill. Usually there are not. And then you'll discuss the timing of the hearing and the pre-hearing disclosures. The hearing itself is usually telephonic, not always, but you'll discuss that also at the hearing. In addition, you'll discuss the pre-hearing disclosures that we'll talk a little bit more about those in a moment. The hearing is routinely scheduled to be a telephonic hearing where everybody appears by telephone. It's a conference call essentially, and that's not always the best way to resolve one of these cases. The hearing officer is certainly permitted to, and in some circumstances will, order a live hearing. That's a hearing in which people actually appear in the same place, in the same room, at the same time to present the evidence. For many of our clients, that's a better choice. This, after all, is a process that's designed to satisfy the due process rights of the Medicaid participant that you're representing. Many of our clients in these cases are not able to effectively participate in a hearing that's held only by telephone. If you have a client that wants to participate, is capable of participating, and doesn't think that they can do so by telephone, those are good grounds to ask for a live hearing. The hearing officer will take up that matter usually at the pre-hearing telephonic conference, may ask for a submission in writing as to the reasons for asking for a live conference, and will ultimately render a decision on whether to do that or not. At that point, the hearing officer will also schedule the hearing and will send out a notice of hearing that also includes a notice of the deadlines for pre-hearing disclosures. After the hearing, there will be director's review and then judicial review, which I'll also talk about briefly. But let's talk about handling the hearing itself. After the pre-hearing conference, the process starts with the pre-hearing disclosures. You'll be ordered by the hearing officer to provide to the other side a list of your witnesses and exhibits, and the other side will be ordered to do the same. This typically takes place either a week or 5 business days before the date of the hearing. The pre-hearing disclosures are straightforward. List the witnesses you intend to call, list the exhibits you intend to use at the hearing. The deadline, like I said, is typically set about a week before the hearing. Oftentimes, we don't quite know yet who are the witnesses and what are the exhibits that we're going to use. You may discover that there's a witness you didn't think was available that became available, that you didn't think you needed, but decided that you did, and that happens after the disclosure deadline. Don't worry about it. Go ahead and disclose your witnesses, disclose your exhibits as early as you can, even if it's after the deadline. Normally, you'll be permitted to put them on, even if the disclosure is a little bit late. In a worst case scenario, you don't know you need a witness until you're actually at the hearing. Even then, it might not be too late to get another witness onto your list. Let everybody know as early as possible that you think you need to call this witness. They weren't previously disclosed. Explain why they weren't previously disclosed. And quite often, I imagine, you're going to be able to get the hearing officer to allow you to put the witness on or to introduce the exhibit. Finally, although this is not set out in rule for these proceedings, in court proceedings, it's common, and therefore the lawyers who are the hearing officers will be familiar with the idea, that you don't need to disclose items that are only offered for purposes of rebuttal. So if you have a witness that wasn't part of your case in chief, that you hadn't planned on putting on, that became necessary only as a result of something that the department said or some point the department made in their case, that's a rebuttal witness. Same thing is true of documents that only become relevant as a result of the evidence that the other side put on. Those are rebuttal exhibits. Those can usually be introduced even though they weren't included in your pre-hearing disclosures. Once you've done the pre-hearing disclosures, received the disclosures from the other side, you'll start prepping for the hearing itself. The hearing is pretty informal. As I said, it's normally telephonic, but it also follows the basic format of a court trial. You'll start with an opening statement. The opening statement is an opportunity to provide a summary of the evidence you're intending to present, to provide some orientation for the hearing officer to the issues, to discuss the evidence that's about to come in, why it's relevant, and what you hope they'll conclude at the end of the case. This is not the time to get all Perry Mason. You're not arguing your case in an opening statement. What you're doing is explaining your case. You're providing a roadmap, you're providing some foreshadowing, you're explaining what you want the hearing officer to learn over the next several hours. After the opening statements from each side, the parties will begin to call witnesses. As has been explained elsewhere in this presentation, on witnesses there will be both direct examination questions and cross-examination questions. Almost always, the Department of Health and Welfare will be asked to proceed with their witnesses first. In court proceedings, who goes first is determined by who has the burden of proof. In proceedings on appeals in budget cases or appeals of plan denials, typically the department goes first for the simple reason that the department has the best grasp of all of the evidence and all of the reasons why they set the budget the way they did or denied the plan that they did. And so it's simply a matter of administrative ease for them to go first. The department will call their witnesses. That will often include somebody from Liberty Health, the assessor. It will often include a regional care manager or other personnel from the Department of Health and Welfare who are familiar with the case. They'll present their explanation of why the budget was set the way it was or why the plan was denied and the reasons for that. You will have the opportunity to cross-examine those witnesses. And as is explained elsewhere, cross-examine those witnesses by using leading questions, by trying to get the other side to admit the facts that are good for your case. Cross-examination is not where you make your case. I want to be perfectly clear on that. Cross-examination is where we may try to get some admissions on the record. We may try to get a few facts sorted out and clarified. But if you're relying on cross-examining the department's witnesses to build your case, you haven't prepared the proper case. Usually we cross-examine witnesses solely to demonstrate that they are biased, that they have incomplete information, or to get admissions to things we think they will admit. For building our case, for supporting our clients, we want to rely on our own witnesses whenever possible. Throughout the course of the hearing, you're going to be using exhibits. Any document that you've presented as an exhibit should be there for a reason. We don't just paper the file to paper the file. In fact, presenting the hearing officer with documents and papers that they're not going to rely on is counterproductive. That gives the hearing officer reasons to focus on things that we don't want them focused on. We want them to look at the documents that we think are relevant to proving our case. In the course of doing that, with each document, think about which witness is also going to talk about that document. Now, it's not that every document needs a witness to discuss it, but for most of them, there's something in particular we want out of that document, and the best way to draw attention to that is by asking witnesses questions about that particular item. So in your preparation for the hearing, also lay out which witnesses are going to talk about which documents, which parts of those documents you want to draw attention to, and why you want to draw attention to them. After both sides have presented their witnesses, have presented their exhibits, and all the evidence is in, the hearing officer will usually provide an opportunity for a closing argument. A closing argument is the time to get all Perry Mason. This is when you make the best argument you can for your client. This is when you point out that The law is on your side, the rules are on your side, the facts are on your side, and justice is on your side. And if you don't have all of those, well, 2 out of 3 ain't bad, so do the best that you can. But the point is, you're making the argument to a hearing officer who is trained as a lawyer, who wants to understand what is it in the IDAPA rules or in the federal regulations or in the Medicaid program that requires the outcome that you're asking for. So keep in mind that yes, you're making a persuasive argument, but the person you're trying to persuade wants to know how it fits into the law. That's the hearing process. There's also a process that goes on after the hearing is concluded. You'll have very little, if any, involvement in that. After the hearing, first you'll get the hearing officer's preliminary decision. These are almost always made available within 30 days of the hearing. The decision is called a preliminary decision because it is not technically a final decision. The hearing officer is rendering a decision that will become a final decision, but only if certain things do or don't happen. This is the hearing officer's best assessment of what he thought of the evidence, what he thinks the facts are, and how he thinks those facts apply to the relevant rules governing the program. The hearing officers hear decisions or hear cases from throughout the health and welfare program and probably from other programs across the state. These are not folks that commit the bulk of their time to the Medicaid DD program. And so they are often not as expert on the program as you and I might be. So expect that there will be hearing officer decisions that you disagree with. That's going to happen. Unfortunately, there's very little that you can do as a suitable representative and within the suitable representative program after that decision is rendered. There are opportunities for further appeal. And at least the first step in that further appeal you may consider taking, but as I'll discuss later, unfortunately you're not going to get reimbursed for your time beyond the issuance of the hearing officer's preliminary decision. The further appeal the first step is to seek the director's review of the decision. The director of the Department of Health and Welfare is the next step. The appeal is made to him. The process is straightforward and is actually set out at the end of every hearing officer's decision. The decision will explain that within a certain number of days, usually 14 days, you may appeal by submitting a statement of reasons for appeal to the director, and it'll provide the address where you send that. The statement of reasons needs to be a little more detailed than did the original notice of appeal. As I explained earlier, a notice of appeal of a budget or a plan denial doesn't need to be particularly detailed. Here, you want to provide actually a statement of what are the particular reasons that you believe the hearing officer's decision was wrong. What mistakes did he make? Which facts did he find that were not supported by the evidence? Which rules did he misapply in your opinion? Which rules did he ignore or not apply? When you submit that to the Department of Health and Welfare, that will then result in the issuance of a briefing order from the director's office. You'll be directed to submit a written argument in support of your statement of reasons for appeal within several weeks. It'll vary. If you need additional time, you can ask for additional time. All of this is beyond the scope of what can be reimbursed under the KW settlement. So it would be a good time to consider whether your client actually needs a lawyer to handle this part of it. Of course, that also means figuring out a way to make sure that there's a lawyer available and willing to handle it. After the director's review, there is a final step of review called judicial review. If your client is still unhappy with the decision that was rendered, that decision can be looked at by a district judge here in Idaho. The judge has limited scope of review. He can only overturn a decision for certain specified reasons. And unfortunately, that process does require either that your client be capable of representing themselves or that they hire a lawyer. A suitable representative is not permitted to bring or to file a petition for judicial review of the director's decision. That's the hearing process. Hopefully, you'll resolve most of your cases either in the pre-denial process in working with the care managers or in the informal review process. But learning how and when to handle the appeals gives you that extra ability to know that if it comes down to a fight, you're ready to have the fight. Hopefully this is helpful to you and will ensure that you're ready to represent your clients.